Data privacy in the European Union. We will look at it, but as I told you, so the GDPR was actually implemented on May 25th, 2018, but it was not the first law. The Council of Europe Convention of Europe 108 was basically the first law on data protection that came into Europe, which expressly talked about protecting personal data within Europe. And after that came the Data Protection Directive, but it was a directive and it guaranteed maximum protection. It was not member states could make changes into that. Then came in GDPR. GDPR is a regulation. There is a difference between a directive and a regulation. So the European Union has now changed its way into implementing laws. Now the EU is trying to have more regulations and not directives, because regulations guarantee a blanket level of minimum protection across all European member states, that everybody is getting that amount of protection. Because some countries where you have more corporations, maybe where you have big players who are settled, they would like to have easier laws where they can allow these companies to work in and manipulate the local legal atmosphere so that they can capitalize more on that. They can have more data. So to prohibit that, or at least to restrict that, EU has come up with this new regulation-based legal principle where they try and implement regulation instead of directive, so that a minimum blanket cover is offered to all the member states, all the residents of member states. So yeah, now coming back to GDPR, it was implemented in on May 25, 2018, and it is directly applicable and enforceable as a law in European Union member states. And it guarantees this maximum protection of data subjects through uniform set of data protection rules. So when I write here maximum protection, and when I say that it guarantees a bare minimum to all members, it actually means the same thing. It's just that what I intend to tell you here is that this is the law, and the law has certain rights and restrictions that are applicable, at least that are applicable. And when it is a restriction regulation, it says that this is applicable. The countries can make more restrictions. However, under a regulation also, the countries have certain free hand that on certain provisions they can make their own laws, like they can change it within the country. As talking about maximum protection, this is the law that is that has given maximum protection to all the member states till now when it comes to protection of personal data. So it's that. The GDPR, however, has 50 provisions where the member states can make their own regulations. They can change it. I have given you just one, that consent by children. The GDPR says it should be 16, but even in Finland, the consent is 13. I am not sure how intelligent a 13-year-old is to give consent and throw away the personal data that easily just to use whatever websites they want to use. So it is a little difficult there. But yeah, most of the member states within the EU have changed that consent age to 13 from 16. 16 was provided in the GDPR. So according to the European Commission, it serves as a means for third countries also to adopt basic tenets of protection of data protection, similar bills. So what the EU thinks about the GDPR is also a form of, if you talk academically, it's a form of neo-colonialism. Why neo-colonialism? That it is a new form of colonialism. They've come up with a law. Now they want the world to adopt that law. They're colonizing through a law, which is not really true and which is not really false also. They've come up with a very strict law and they want all the states, all the countries across the world to adopt similar law, not GDPR, but something similar. It doesn't really restrict having businesses outside Europe. You have something called adequate country list, where any country who has a law that is similar to the GDPR, they can have an agreement, SCC, standard contractual clauses, and businesses can easily work that way, signing that SCC and looking at technical and organizational measures. If it doesn't, for example, US has regulations which are very difficult to understand and which are very tricky also. And it's easy for US government to ask for any kind of data. However, a lot of business goes on between Europe and US. So it has not stopped anything, but yeah, it has increased a lot of paperwork and privacy compliance checks. Yay, lots of privacy work in Europe actually. So that it's given rise. And I think as per a recent survey where I read that more than 73 privacy professionals would be required by 2025 in Europe alone. So think of the world. This strict bill has at least given rise to this. And we all should be very happy that we are experiencing this growth of a very new law, and nobody really knows many provisions. For if anybody has followed the Facebook case, I remember when I was studying at the university, controversy. Processing vital clauses was under the legal rules of processing. Vital clauses was something that nobody really discussed. But Facebook, in the last case where it was fined so heavily by the Irish data protection officer, used standard contract, vital contractual terms as the basis of processing. And now we have a whole case on basis of processing, which we will do when we reach there. But it's evolving. The meanings are coming out and it's changing. The EDPB gives a new guideline, then there is a case on that. Anybody who's interested in GDPR should really, I would say, appreciate this, that we are somewhere, we are seeing a new law is being evolved and we are in the middle of it. All of us who are interested and reading about it, actually.